All right, so now you've got to, here you are, you're the new man, and you've got to have this manual, and this manual is designed to train you to be an IRS agent. The way I figure it, if you're a good, competent, trained IRS agent who's smart enough to go out and catch some other dumb citizen, you ought to be smart enough then not to get caught by some other smart enough IRS agent who's smart enough to catch a citizen but not smart enough to catch another IRS agent. That's the way I got that figured. Now let's come down here to number 221, knowledge of law and evidence. Okay, so you have to have some knowledge of law and evidence so that you can gather evidence based upon law so that your evidence won't be thrown out of court. Therefore, as soon as you know what kind of evidence can be supported in court and what cannot be supported in court, you deprive your enemy of the evidence that can be supported in court and let him have the evidence that cannot be supported in court. See how simple that is? Planning and conducting investigations involves the application of knowledge of the criminal and tax laws contained in the Internal Revenue Code, Title 26, United States Code, and the Criminal Code, Title 18 of the United States Code. Title 26 is civil, Title 18 is criminal. Together with a working knowledge of the fundamental rules of evidence, Handbook subsections 222 and 223 concern general information relative to law and evidence. Okay, let's stop right there. You go to your local law library, and I think it's Kelly's Rules of Evidence. Just go in and ask your law librarian for a book on rules of evidence. You read the book. There'll be some big, thick books. It's like studying anything else. The more you learn about evidence, the more competent you're going to become. That's exactly what they're telling their agents, and that's exactly what I'm telling you. I think you need Kelly's Rules of Evidence. These guys need Handbook subsection 222. Specific laws encountered in the intelligence investigations are set forth in Chapter 100. Trial procedure is discussed in Handbook Chapter 600. And the sections of the handbook concerning particular investigative devices, techniques, and procedures such as interviewing witnesses and obtaining documentary evidence include information relating rules of evidence. All right? So there's what your agent is going to have to study. Definitions of law. Laws are rules of conduct which are prescribed or formally recognized as binding and are enforced by the governing power. Number 2, common and statutory. Okay, you got common law rules, and statutory are equity rules. Okay? Number A, common law comprises the body of principles and rules of action relating to government and the security of persons and property, which derive their authority solely from usages and customs or from judgments and decrees of courts recognizing, affirming, and enforcing such usages and customs. Isn't that what I've been telling you all the time? I wouldn't have known this if I hadn't learned it from my enemies. B, statutory law refers to laws enacted and established by a legislative body. All federal crimes are statutory, but common law is frequently resorted to for defining words used in the statutes. For example, statutes provide penalties for attempted evasion of income tax, but they do not define the terms attempt and evasion. Gosh. So when you get into court, I guess a couple things that you want to ask your adversary, particularly concerning the complaint. What do you mean by the word attempt? And what do you mean by the word evasion? You see, these definitions of words are extremely important. I wouldn't have known that if I hadn't looked at my adversary, who told me that these words were very important. Number 3, substantive and adjective. Substantive law creates, defines, and regulates rights, duties, and responsibilities and obligations, whereas adjective or remedial law provides rules for enforcing rights or obtaining redress for their invasion. Adjective law provides rules of practice concerning proceedings before, during, and after trial, and rules of evidence relating to the admission of evidence at trials and the testing of the credibility and competency of witnesses. And number 4, civil and criminal. Criminal law is that branch of law which defines crimes and provides punishments. Civil law relates to the establishment, recovery, or redress of private and civil rights. How simple that is? Gosh, they just lay it right out for you, don't they? If there's any of these words now as I go through that you don't understand, haul out Bovier's or haul out Black's Law Dictionary and study those terms. Don't allow yourself not to know and understand words that have different meanings when you get out on the street from the meaning that it has when you get into the courtroom. All right, definitions of crime. An act is a crime against the United States only if committed or omitted in violation of a statute forbidding or commanding it, or in violation of a regulation having legislative authority. Crimes are classified and defined in Sections 1, Title 18, United States Code as follows. Now here they're going to tell you what crimes are. Let's see if what I've been telling you in the past is anywhere near correct. We'll find out what they say. Notwithstanding any act of Congress to the contrary, number 1, any offense punishable by death or imprisonment for a term exceeding 1 year is a felony. Oh. Number 2, any other offense is a misdemeanor. And number 3, any misdemeanor, the penalty for which does not exceed imprisonment for a period of 6 months or a fine of not more than $500 or both is called a petty offense. Well, they've classified misdemeanors here in 2 categories. Petty offense and a misdemeanor. As a matter of practical fact, a misdemeanor and a felony is part of the rule of 222. You've got civil or criminal, and you've got felonies or misdemeanors, and you've got common law or equity. That's the 3 branches, the 3 rules of 222. All right, parties to a criminal offense. You can read that and go on down here. It tells you what the parties are. Let's take a look at what the definition of evidence is and see what we've got. Evidence is all the means by which any alleged matter of fact, the truth of which is submitted to investigation, is established or disproved. The investigators obtain evidentiary facts which by inference tend to prove or disprove the ultimate main or principal fact. The latter is a matter for determination by a court or jury. For example, a special agent obtains in connection with a net worth case documents and oral statements. That's evidence in confessions and admissions in street language, showing that a taxpayer's bank balance has increased substantially. Let me ask you a question. What if you didn't have a bank balance that increased substantially? What if you had a cache of silver and gold coin in your basement that increased substantially? That is an evidentiary fact from which an inference may be drawn relative to the ultimate or principal fact, namely that the taxpayer, but I'm not a taxpayer, willfully attempted to evade income tax. Legal evidence is such as is admissible in court under the rules of evidence because it tends reasonably and substantially to prove a fact. Evidence is distinguished from proof in that the latter is the result or effect of evidence. In other words, evidence are 3 facts that prove the truth of the matter or the fact of the matter. Okay, now you've got classifications of evidence. Number 1, there is direct evidence, and that is which, if believed, proves the existence of the principal or ultimate fact without any inference or presumption. It is direct when the very facts in dispute are sworn to by those who have actual knowledge of them by means of their senses. It may take the form of admissions or confessions made in or out of court. Remember, the first rule of a competent pro se is don't say anything, keep your mouth shut, and shut up. Because you see, if you're making admissions and confessions and statements, then they may take the form of admissions or confessions, and then that is called direct evidence. You'll never get into any trouble for anything that you don't say. Well, I guess I'd have to qualify that. Sometimes if you don't take an oath, you can go to jail for contempt. I've had that happen. Number 2, circumstantial evidence is that which tends to prove the existence of the principal fact by inference. The use of circumstantial evidence is recognized by the courts as a legitimate means of proof, and it involves proving several material facts, which, when considered in their relationship to each other, tend to establish the existence of the principal or ultimate fact. In the absence of a confession, got that? No confession of a witness to whom the violator has expressed his intent, violations involving willful intent are proved by circumstantial evidence. Indeed, it is the only type of evidence generally available to show which elements of a crime as malice, intent, or motive, which exist only in the mind of the perpetrator of the deed. The proof of most internal revenue violations, therefore, is based on circumstantial evidence. And the circumstantial evidence that they're putting together against you, done by inference. Remember the other rule? All of the evidence that's ever going to be used against you is going to be furnished by you. You know, if you'd quit furnishing evidence and quit making admissions and confessions, I think you'd be about 90% of the way home free in a tax case. Well, in any case. Circumstantial evidence includes direct testimony as to secondary facts which are relied on to establish the main fact in issue. For example, in a tax evasion case, a taxpayer's customer testified that he paid $10,000 for merchandise, and a government agent testifies that the payment does not appear on the taxpayer's books and tax returns. Those facts constitute direct evidence of the omission of $10,000 in income, but not of the main issue, which is, did the defendant willfully attempt to evade income tax? Okay? Let me see if I understood that. My customer gives me a check for $10,000, and I take the check down to my coin dealer, and he gives me 1,000 silver dollars. Okay? I've got a receipt from my broker, don't I? Now, from my broker, I now have $1,000 of income, not 10,000 Federal Reserve Note trade unit credits, which are not money of account. Give you any clues? Looks like to me about that point I've got $1,000, and I think I could go right in there on the courtroom floor and argue that one pretty succinctly and successfully. Now, when I need to pay a bill or two, I take the dollars down and trade those for Federal Reserve notes, and then I pay my bills with Federal Reserve notes, so I then have the best of both worlds. Seeing as how my government doesn't want to make a differentiation between a dollar made out of copper and a dollar made out of silver, I can use that then to my own legal and lawful advantage, can't I? A, in addition to proving intent, what's my intent? To evade the tax or to avoid the tax? See, intent now comes into play. My intent is to manage my affairs in such a way that I may avoid any unnecessary taxation. And that's legal and lawful, and there isn't any reason in the world why you shouldn't avail yourself of the tax loopholes, if that's the correct word, that exists. I mean, after all, there's depreciation allowances, there's investment tax credits, and there's one-time only sale of your house. Why not convert your money into silver coin and then convert the coin into trade units and then record the instrument? Watch what you've got. A $10,000 check from your customer, and you trade it and you get a receipt that proves that you only got $1,000 for it. Then you turn around and give it to the man again and take ferns and pay the ferns, which proves that you paid out $10,000. Why, when you get to the end of the year, all you're going to have left is losses. You'll take in $5,000 and pay out $90,000. And they'll say, well, how did you do that? God, did I have a bad year this year? And you've got all the receipts to prove it. And you've got the money to prove it. And you've got the law to prove it on the courtroom floor. You can document that in any court in the land. I don't see why anybody who's even in the income tax system would have to pay any income tax. Or in any event, darn little. You can't be compelled to pay your taxes in silver. You can go up and pay your taxes in Eisenhower and Susan B. Anthony dollars. See how simple that is? And there's all of your receipts from all of the people. Gosh, what losses a person with a little reason, logic, and common sense can put together. We'll cover this in more detail, and I'll give you some charts and graphs when we do the income tax special. You know, there's another thing called land. You know, you can claim land. But it's like I've said before, people will come in or they'll write us and say, we don't want to go through all this baloney here. What we want is the land issue. Can you show me how to go out and claim public land? Can you show me how to stop paying income tax? You know, that's what I really want to do. I liken that to the guy who's only interested in sex before marriage. He's not interested in the job, the house payment or the rent or the hospital bills for the babies. You know, there's about 90% of marriage that has something other than sex in it. But of course, most men are only interested in sex. What we want is the frosting. We don't want to be burdened with the cake. And of course, that's what people are telling me. They'll come in and say, well, all I want to do is get out of the tax system. Well, what good is it to get out of the tax system if you can't defend yourself on the courtroom floor, or if you can't manage your affairs in such a way that you can avoid the tax? How many accountants do you know that can tell you, well, here's the law, here's the Coinage Act of 1978, 1965, 1853, 59, 1792, and here's the way to manage your affairs so that you don't have to pay any tax? I haven't met one of those. I used to turn all my money over to accountants, and all they did was rob me and send the balance off to the IRS and leave me a pauper. And then when I was about 37, I learned how to count. And I was fortunate to learn how to count by age 37. Most people that are inflicted with the government schools never learn how to count. Let me turn over here to classifications of evidence here. Where was I? Yeah, I'm going down this classification of evidence. I'm going to start here at number 2. I'm over here on, there's no page, it says 5041.2, direct evidence. So, circumstantial evidence is that which tends to prove the existence of the principal fact. The proof of most internal revenue violations, therefore, is based on circumstantial evidence. Did the defendant willfully attempt to evade the income tax? Down here, where it says A and B at the bottom on the inside column, in addition to proving intent, a subject covered in greater detail in subsection 3111.2 on willfulness, circumstantial evidence is also frequently used to prove unreported income as shown by increases in net worth, expenditures, or bank deposits. Bank deposits, expenditures, and net worth. More confessions and admissions. Circumstantial evidence may be as cogent and convincing as direct evidence, and the jury may properly find that it outweighs conflicting direct evidence. However, the inference must be based on convincing facts and must be more probable and natural, or must be a more probable and natural one than other explanations offered. The Supreme Court in the Holland case, now notice number 1 there. Here's your footnote. 348 U.S. 121. Stated as follows. Now these guys are going to quote something out of a case. Now remember what I've told you in the past, and I'm going to tell you in the future. You cannot believe anything that you read here. What you can do is read this, and here's a quotation, and that quotation, if it's quoted correctly from the Supreme Court case, which it may or may not, and I'll tell you, I've seen a lot of quotations quoted out of context, which are just plain blatant lies, trying to show something that isn't true. Or it's quoted and it's used off point, and used off point to convince or to show or to prove their position. And when you read this case called U.S. versus Holland, you're liable to find the exact opposite of what they're claiming here. But let's take a look at what they're claiming. And then we go to the law library, and then we take a look at the Holland case and find out whether or not we're being lied to. Remember, from Miranda, our Supreme Court told us that it is very common for the police to give false legal advice. Remember that? False legal advice. So when your adversary is giving you information, it could be false legal advice. And you can't believe anything I tell you, and you can't believe anything these guys tell you either. Circumstantial evidence, this is a quotation from the Supreme Court, in this respect, is intrinsically no different from testimonial evidence. Admittedly, Circumstantial evidence may in some cases point to a wholly incorrect result. Yet this is equally true of testimonial evidence. In both instances, a jury is asked to weigh the chances of the evidence correctly pointing to guilt against the possibility of inaccuracy or ambiguous inference. In both of those, the jury must use its experience with people and events in weighing the probabilities. If the jury is convinced beyond a reasonable doubt, we can require no more. Evidence may be positive or negative. Evidence is positive when it relates to proof that a fact did or did not happen or exist. Evidence is negative when a witness states that he does not have knowledge of the happening or existence of a fact or circumstance. Okay? So all they're doing here is basically laying out and telling the prospective agent what it is that he needs to know about gathering facts, figures, evidence, where to go, bank accounts, records, books, subpoenas, summonses, and things like that. And as we go through here, I'm going to show you what it is exactly that these agents learn. And it's basically pretty simplistic baloney. There isn't much in here other than reason, logic, and common sense. My reason, logic, and common sense tells me already that if I just got rid of the bank account and threw all my records away and burned the records that I've had for a long time, they probably couldn't get enough evidence against me to put a case against me. Now, I'm not recommending that you go out and burn all your records. And I want to just lay this on you real quickly, because if you've been filing tax returns, in 1979 and 1980 and 81, you've already made the admission and confession. That 1040 form was exactly that. And so if they say, I want to audit your 1980 return, you'd better have all the checks and documents that can back up all of your deductions, because you've been playing the game. Now you've got to have all the facts and figures to back up your position. My point is, if you're a person who doesn't have income, then my logic tells me that you're probably a person who doesn't file tax returns. Does that make any sense? I don't file any tax returns. I haven't had any income for 3 or 4 or 5 years. I retired, remember? Well, since I retired and I don't have any income, I don't fill out any forms. And since I don't fill out any forms, I don't have any bank accounts. I don't have any records and books. So therefore, there isn't any evidence, whether direct or indirect, whether circumstantial or factual. And so therefore, there's no case against me. So therefore, who is it who's going to testify that I've got any income? That's basically the way that works. Let's drop down here to the bottom of the page and take up relevancy, materiality, and competency. Here's 3 elements then in a case. It has to be relevant, it has to be material, and it has to be competent. It says, to be admissible, evidence must be relevant, material, and competent. Well, it makes sense to me. If the information that we're talking about is taxes, and somebody brings up the subject matter from a witness of the mating habits of the tsetse fly from the Ituri rainforest of the Belgian Congo, objection, Your Honor, that's not relevant. Or it's not competent. See? Failure to object timely is fatal. So when you're in the courtroom drama, it's a very simple matter of sitting there and listening to the dialogue. When you're listening to the dialogue, it's simply a matter like any businessman in any kind of business deal. If the fellow is testifying about facts, figures, numbers, we let the information in. And when he gets to talking about things that are not factual or not competent, not relevant, then we object. And that's called a specific objection. See, there's 2 kinds of objections, general and specific. When you simply say, objection, Your Honor, that's a general objection. Has no real meaning in the record or the transcript. But when you say, I object, Your Honor, the information is hearsay. That testimony is coming out of the lips of a man who says he heard from somebody what they said. And I object to that hearsay evidence. Now, that's a specific objection. And you're objecting to the competence of the testimony that the man is offering. An example of that would be an IRS agent who's testifying, and the prosecutor or the attorney general would ask a question. Now, Agent Smedley, did you go to Defendant Gordon's bank? Yes, I did. And did you talk to anybody there? Yes, I did. And did you get Defendant Gordon's checkbook and his check register and microfilm copies of checks? Yes, we did. And did you talk to the teller? Yes, I did. And who did you talk to? I talked to Mary Jane. And what did Mary Jane told you? Well, Mary Jane told me that Mr. Gordon came in and blah, blah, blah. As soon as the words, and Mary Jane said, objection, Your Honor. Mary Jane is not here for me to cross-examine. See how simple that is? All right? That's not competent testimony. It's not that it's irrelevant. Mary Jane might have some real good information, but they're going to have to bring Mary Jane in and put her on the stand and let her testify about what she knows, what she heard, what she saw, what she can relate. Okay, if a fact offered in evidence relates in some logical way to the principal fact, it is relevant. Okay? If we're talking about taxes, and Mary Jane is on the stand, and she's the bookkeeper from the bank, and she testifies that Defendant Gordon came in and made a deposit of $10,000 with a check drawn on the ABC company, that's relevant. That's a deposit. And then if she says, and then he came in and made a withdrawal in cash with a check of $5,000, that's relevant. Has to do with income and outgo. And then when they say, and isn't it a fact, Mary Jane, that Mr. Gordon is a homosexual? Objection, Your Honor. The sex habits of the defendant are not relevant in this case. You see, they may call you a homosexual, or they may call you a criminal, or they may say, haven't you been arrested, or something like that at some other time. The only purpose for doing that kind of a maneuver is to tell the jury that you're a queer. Then the jury isn't convicting you of tax evasion, they're convicting you of being a queer. Okay? Now, being a queer could be real beneficial to you in San Francisco. It could be real tough on you in Boise, Idaho. So, you need to use a little reason, logic, and common sense here too, you know. The word relevant implies a traceable and significant connection. A fact need not bear directly on the principal fact. It is sufficient if it constitutes one link in a chain of evidence, or that it relates to facts which would constitute circumstantial evidence that a fact in issue did or did not exist. One fact is logically relevant to another if taken by itself or in connection with other facts. It proves or tends to prove the existence of the other fact. Okay? They're trying to show that I failed to list $10,000 in income, let's say. Okay, don't you see that check for $10,000 that I deposited then becomes very relevant, and the $5,000 and the next $3,000 and the next $2,000 checks that I went in and drew and took it out in cash are very relevant. Okay? If the fact is logically relevant, it is also legally relevant unless it is barred by some rule of evidence. Now, rules of evidence are very important also, and the rules of evidence are going to come from the civil rules if it's a civil case, or criminal rules if it's a criminal case. Now, if they got the evidence and they didn't have a Fourth Amendment search warrant, and they did it against your will and over your objection, let's say they broke into your office in the middle of the night like the feds did in the Daniel Ellsberg case, that evidence has to be excluded because the Fourth Amendment excludes it. Understand how that works? See how simple this whole thing is? So, under the rules of discovery, you demand of your opponent all of the evidence and information that he's going to use against you, including all the witnesses, and then you just lay it out here, and then you analyze it to determine what is it that's damaging and what isn't damaging, and then you know what it is that you have to overcome. The $10,000 check. Oh, I want to bring the man in who wrote me the $10,000 check. Oh, that $10,000 that I deposited and then took out in cash, $5,000 once, $3,000, and then $2,000. Oh, yeah, that was old Sam Spade, and Sam gave me that check, and I deposited in my account, and I took the money out and gave it to him in cash. That wasn't income. Why, I just deposited a check for him because he wanted me to cash it. He needed some cash in order for him to do some business. That wasn't income to me. Why, I just deposited the check for him And of course I didn't declare it as income because it wasn't income to me. I deposited $10,000 and I'll just bring Sam in, put him on the witness stand, and here's what Sam will testify to. Or on cross-examination, if they should bring him in as their witness, Sam, did you give me a check for $10,000? Yes, I did. And did I deposit it in my bank? Yes, you did. And did I then give you $10,000 in cash back? Yes, you did. Did I make any profit off the $10,000? No, you didn't. You see what happened? They thought they had income tax evasion, but they really didn't. And by knowing from discovery that they were going to call him as a witness and that that check was a principal or a major factor in their case, when I got to court, then I was prepared, wasn't I, to then rebut and refute their testimony. But if I were to overlook discovery and I didn't move for discovery and I didn't know what they were going to use against me, I'd be totally surprised. I wouldn't know or remember that particular check. It was only one deposit out of 500 checks cashed, maybe per month if you're running a pretty good sized business. And then you sit there and go, well, what check was that? And who did I get that for? And gosh, what did I do with the money? You see, you'll sit there and wonder, gosh, even I don't know what happened. And they're putting a case together against you. You're totally innocent, and you can't even defend yourself because you don't know what the facts are. So, one of the primary duties of an executive officer in any company or corporation I know of is that he's got to be prepared for each and every eventuality that comes up. You know, when you come to the office, don't you bring your briefcase? And in your briefcase, don't you have some order blanks in case somebody comes in and says, you know, once in a while a guy just walks in off the street and says, hey, I'd like to place an order for a truck and trailer load of furniture. Here's a $20,000 or $30,000 order, and you don't have any order blanks? Come on. You know, a businessman has to be relatively prepared, you know, for eventualities. Doesn't it make sense to you then that when you get into the courtroom that you should be prepared for the eventualities that are going to come up? Shouldn't you prepare your case before you get into the courtroom? You know, most of these public defenders never prepare. They just walk into the courtroom. They don't need to prepare. They're not there to win. They're just there to represent you, make sure your rights aren't violated as the prosecutor conviction sends you off to jail. And probably not more than one lawyer in 10 is prepared to do much better than a public persecutor, public defender, however you want to word it. No, you'll have to pay a pretty penny to get a lawyer who will come into the courtroom and fight and argue to win your case. I know of a couple of three like that, but not very many. And let me tell you, when you're the one that's on the hot seat, there's a whole lot more adrenaline flowing through your heart and through your body to make you prepare for that particular case. Going on then, evidence is material if it tends to cast light on the subject in dispute, to affect the outcome of the trial, or to help establish the guilt or innocence of the accused. When you look at that evidence, you want to list it. There may be 20 pieces they're going to use against you and 10 witnesses. List the 20 pieces of evidence and the 10 witnesses, and then you bring in 10 witnesses to refute what those witnesses are probably going to testify to, and the 20 pieces of evidence that they're going to use against you. You need to be able to answer each and every piece of that evidence, whether it's a tax case or a criminal case of whatever kind. Not all relevant evidence is material, but all material evidence is relevant. But all material evidence is relevant. For example, where the defendant has already acknowledged his own handwriting in court, proof of his handwriting through an expert would be immaterial because the fact has already been sufficiently proved. That's also called stipulating to the facts, you know. Is that your check? Oh yeah, I wrote all those checks. I'll stipulate that those checks are already mine. Okay? You know, one of the things I notice in these tax cases that comes up so often, and I guess I ought to just mention it right now, no one is prepared to go into the courtroom to defend their tax position. They're taxpayers, and they don't want to admit that they're not taxpayers, even if they're not. And they want to fill out Fifth Amendment tax returns. Fifth Amendment tax return is a pretty poor return, in my opinion, if you're in the tax system and you've got income. If you've got checks floating around out there and credit cards and invoices and receipts floating around out there. Now, I'm not saying that the Fifth Amendment return is a poor return in all cases because, you know, if you're in the marijuana business and you're hauling marijuana up from Florida, you don't necessarily want to report that you sold $55,000 worth of marijuana, and you want to list $23,600 in fuel and expenses for traveling back and forth hauling it back to Idaho. I mean, doesn't your common sense tell you that? So if you were backed into a corner and you had to defend that position, you'd want to take the Fifth Amendment on that particular item because you could be prosecuted for that item. So let's understand that the Fifth Amendment is only relevant when you're in imminent danger or fear of being prosecuted for some other criminal offense, not civil, but some other criminal offense. So most of the time, as I've observed it, the Fifth Amendment is used improvidently, and the Fourth Amendment or the First Amendment should be applied because it's a privacy matter. You have a right to privacy in your own papers. Remember? Hale versus Hinkle. But when you're in a corporate capacity, you don't have any rights to privacy or the Fifth Amendment. The Fifth Amendment only comes into play when you're in dire fear. And you're going to have to testify to this. Your Honor, I can't answer that question because I'm in fear that I'll be prosecuted, and if I were to tell you what it was that I could be prosecuted for, that would be the beginning point of a criminal investigation. So therefore I decline to answer unless I get immunity from prosecution. We did this one time in court, and it was really hilarious. And this was a tax matter, so it's relevant to this case, and explain to you how this came down. This man is being charged with income tax evasion, and so they want his daughter to come in as a third-party record keeper and testify in front of an IRS audit as to some money and transactions or something that allegedly occurred between her and her dad. Well, she didn't want to testify against her daddy, so the first issue that has to come up in a case like that, or ought to come up, would be this thing of the Fifth Commandment, honor your father and your mother. Well, in this particular case, we didn't raise that. That was a defense that we were going to use later. And this young lady was prepared to go to jail for contempt for the rest of her life. And anytime you make the commitment now that you're going to stand on your constitutional rights or go to jail, when they take you to jail, you better be prepared to stay there for the rest of your life. If you don't have that kind of a commitment, then don't waste your time going to jail. If you're going to capitulate in 2 or 3 days, or if you're going to become claustrophobic while you're in jail, just shut up, tell them what they want to know, be a good slave, go get the straw, make the bricks, and don't make waves, and you'll get along better. If you're not going to gather the straw, if you're not going to make the bricks, if you're not going to submit to tyranny, well, then you've got to stake out your turf and stick with it. Because you can always win if you'll stick with your constitutional rights or your position. It may take you a week, it may take 2 weeks, it may take a month, but you'll ultimately win. I always remember that movie, Bridge on the River Kwai. I happened to see that on TV the other night, and this colonel, they put him, this British colonel, he told this Japanese colonel, I guess it was, or this Japanese officer, what the law was. This is the law, and we're going to make you obey the law. And this Jap colonel didn't want to do that. So he threw this British colonel into solitary confinement and kept him there for 30 days. And when this colonel came out, he said, well, we'll build your bridge for you. I don't have a problem with that, but you guys are going to have to obey the law. And ultimately, he won out. That Jap wanted that bridge built. And this little girl, she was just reminded me of Pearl Pureheart, you know. And here's Pearl Pureheart, and she goes into court. Show you how this Fifth Amendment works. Well, it's hilarious. Then she's sitting there, and we'd discussed her status. She's about 24, 25 years old, you know, one of these young girls, been to college, you know, and been exposed to drugs and all kinds of wickedness and evil and sin and terrible. And we thought we'd have a little fun with these IRS agents while we were at it. And she'd gotten some bum advice. Well, I wouldn't say bum advice. It was sincere advice, but they had given her about 20 or 30 questions, and she'd answered most of them Fifth Amendment. You know, like, what's your name? Fifth Amendment, and where do you live? Fifth Amendment, and things like that. And I could see when I looked at the interrogatories that she was in real trouble, because when she got into the courtroom, I knew the judge was just going to come down on her and throw her in jail, and she'd be on the left side of the issues. So we came back and we did a little study and a little preparation, and she got into court, and she agreed that she would answer the questions. And so the judge is sitting there. He's the referee, and this IRS agent, he came right down on her. So, what's your name? Are you going to answer our questions today? I don't know if I'm going to answer your questions, sir, until I hear what they are. Well, what's your name? Oh, my name is Pearl Pureheart. And where do you live, Pearl? Oh, I live at 2214 Jones Road, Boise, Idaho, and zip code 83706, and my telephone number is 336-5189 or whatever it was.